Welcome back to this fourth and final segment of the law session on contract law remedies. Before the break, we were discussing the difference between the penalty and a liquidated damages clause, and I ended on the point to say that where, for example, you see a lump sum, this tend to point towards a liquidated damage clause. Of course, on the other hand, it is not an obstacle to the sum which is stipulated being a genuine pre-estimate if the parties have, of course, calculated it as such. Because sometimes, in order to make a precise pre-estimate, it may be almost an impossibility, and therefore it may very well be that a figure just has to be calculated based on the whole surrounding circumstances, as it were. Now, in the case of Murray and Leisure Play PLC 2005, Mr. Morris was employed as the chief executive director. His employer dismissed him with 7 weeks' notice. Under the terms of his contract of employment, he was to be given 12 months' notice or paid 12 months' salary in lieu of notice. Mr. Morris sought to enforce this clause, and the employer argued the clause was unenforceable as a penalty. Well, the trial judge followed the principle in the previous cases and held that in determining a penalty, account had to be taken of Mr. Morris' duty to mitigate his loss, and therefore said the clause was a penalty. Now, if you're thinking about this before I actually go into what the court said, if you've not read the case, then I want you to think about it for a minute. This is an employment contract, which means that I appreciate the position that Mr. Murray has, but it would more likely than not be that the employers drafted the employment agreement. I don't think I am personally seeing a penalty clause situation, but let's see what the court said. The court held that the clause was not a penalty. The clause says the sum may have been generous, but was not unconscionable, and may have taken into account the difficulty in obtaining alternative work of equal value. Another case, of course, which deals with this here is Euro London Appointments Limited and Clessons, which is 2006. The claimant was an employment agency. The defendant was a client of the agency which was looking for workers. The standard terms of the contract said that the defendant would pay 20% of the annual salary for each client they introduced whom the client wished to engage, which seems standard enough. I'm an employment agency. I've done my checks. I've gotten my people. And if you're going to now take them out of my availability pool, you pay 20%. Carried on that in the event that a client terminated the contract within 12 weeks of engagement, the claimant would make a refund based on the amount of time worked. However, this refund was conditional upon the fees having been paid within 7 days of the invoice date. The defendant engaged 2 employees who were introduced by the claimant. Neither of them worked 12 weeks. The claimant commenced an action demanding full fees. The defendant said they were entitled to a refund as the clause depriving them of the right to refund was unenforceable as a penalty. The courts held that the clause was not a penalty as it was not payable on breach of contract. This is very important. Penalties only become relevant when you're looking at breach of contract situations. Court said repudiation is a remedy available for breach of contract in that regard. But as it relates to the situation we're looking at, the penalty there would not be because of a breach and as such enforceable. Could have repudiated, but nevertheless. That then takes us, of course, into repudiation. Repudiation then is one remedy which is available for breach of contract, and basically it brings an end to the contract. It is only available for breach of a condition. It is not available for a breach of warranty. So if you're going to repudiate the contract, it is because, for example, the other side has breached a fundamental term and you then repudiate, which means you treat yourself as discharged. Now, we have raised in the cases of Bettini and Guy and Posada and Spires in our earlier law sessions relating to terms, conditions, warranties, and so on. These were the cases about the opera singers, which we had discussed, as I say, in an earlier session. So the point there, of course, is looking at whether it is a condition or a warranty in terms of your repudiation, because if you repudiate in the face of a warranty, you may be the one who's in breach, and as such, the other party can then seek remedies as against you. Now, repudiation may also be available for breach of an innominate term. Now, a nominate term is where the breach more or less deprives the claimant of the whole benefit of the contract. Again, we had looked in terms at Hong Kong Fur, which shows what circumstances you would be able to treat yourself as discharged when you're looking at an innominate term. Now then, we will look at the equitable remedies. We've focused a lot on damages because there are various aspects and a lot of meat in that area. Now then, let's look at certain other aspects in respect of equitable remedies. Well, the first thing to always remember with equitable remedies, they are subject to the equitable maxims. It means that if somebody has acted less than honorable, that may go towards them not being able to get an equitable remedy. If time has passed, lapse of time is one of the limitations on an equitable remedy. So then, let's consider what are some of the remedies in equity that would be available for an innocent party. Well, the first, of course, is rescission. And rescission is available at the discretion of the judge. And what it does is that it seeks to place the parties back in their pre-contractual position. Now remember, damages is to put the parties in a position they would have been had the contract been performed. If you wish to rescind the contract, you're seeking to go back to a time when you had no obligation under the contract. So it seeks to put you in the pre-contractual position and thus represents an unraveling of the contract. And it is available where a contract is voidable as a result of a vitiating factor such as misrepresentation or undue influence or indeed duress. Now again, the right to rescission may be lost if the claimant affirms the contract, so if he carries on, or where a third party acquires good right in the goods, or again, if there's lapse of time or you cannot restore the party to the position pre-contractual. Now again, I would suggest that you go back to the discussion we would have looked at in terms of rescission and the cases that have previously been mentioned. Certainly, as we looked at it in misrep and mistake, we looked at cases like Karen Universal Credit and Caldwell, Long and Lloyd, and Leaf and International Galleries, and those provide very good indications and illustrations of the remedy in action. The next equitable remedy to consider here is specific performance. Now, specific performance is really saying to the court to let the party do what they're supposed to do under the contract. Specific performance is an equitable remedy available again at the discretion of the judge, and it is an order by the court which requires one party to perform his contractual obligation. Now let's look at a point to be made here. Specific performance is about positive obligations. It tells a party to perform his obligation under the contract. Contrast this with injunction, because an injunction is a negative obligation. Injunction says you should not do something. So it's a court order saying that you shouldn't do something. Well, whilst it is often said that contracts are made to be performed and parties should be held to their contractual obligation, the courts are often reluctant to order a party to unwillingly perform the contract, and specific performance is only available in limited circumstances. So when the court seeks to consider whether to make a grant of specific performance, the courts will look to whether damages would be an adequate remedy. It will also look at the type of contract and whether equity requires such an order. Now then, where the damages are inadequate, that is one factor to consider. So if the claimant could adequately be compensated by an award of damages, the courts will not give a specific performance. And you need to look at a couple of cases, for example, Cohen and Roche and Besic and Besic, 1927 and 1968 respectively, to see this. There are certain types of contracts for which the courts will not award specific performance. So for example, personal service. And it's a public policy consideration because the courts say there that it is tantamount to slavery to make somebody work for somebody else. Again, you're looking at an equitable remedy. All the doctrines apply, not least the clean hands doctrine. If it is going to cause hardship, you should not give it. In cooperative insurance and Argyle stores, we see a sort of department store type supermarket setup where the courts, where they had a lease in a shopping center of sorts, and the idea was that they were to be the anchor store. Now, they pulled out, but the leaseholders were banking on them staying, and they sought an award from the court for specific performance to make Argyle stores stay in the complex. And the court said, well, we can't do that because then we couldn't police it. Another case, of course, we're looking at hardship, Patel and Ali. The vendor and her husband owned a property which they sold. The husband, because he became bankrupt, that held up the completion. But after the contract, the vendor got bone cancer, had a leg amputated. Then she gave birth to her second child, all sort of problems that had come on board. And the purchaser obtained specific performance against the vendor on the basis that she could buy the property. The vendor, of course, didn't want to sell anymore because all these things had happened to her. The last thing she wanted to do was to leave her home. And so, of course, she appealed. And the court considered the hardship. And the court said that when you look at the facts, it would be hardship and there would be some degree of injustice, and they instead awarded damages. Now, you may wonder why the first instance judge was so harsh, but remember, with land contracts, specific performance is sort of the main remedy, and of course, he could have been looking at it like that. Injunctions are another form of an equitable remedy, which are available only at the discretion of the judge. There are different types of injunctions. You have an interlocutory injunction, which is also called an interim injunction, which is only temporary until there's the full court hearing. You can get a prohibitory injunction, which stops you doing something, a mandatory injunction, which makes you do something, and there is generally an overlap between the mandatory injunction and specific performance, of course. But the general rule of thumb is when you're looking at a specific performance, you're looking at the positive obligation, and when you're looking at an injunction, the negative. Couple of cases which are important. Page 1 Records and Britain. This was about a pop group who had contracted to appoint the plaintiff as their sole agent and manager for 5 years. And they agreed not to act in such a manner as to appoint any other person for the time being. They had a falling out with the manager, as you do as a pop group. And of course, the plaintiff sought an injunction. The court said that the injunction must be refused because effectively it would act as compelling them to have him as their manager. Here's the question then. Can you get an injunction which effectively is specific performance? So suppose I say to you, I will stop you not firing me. That's like a double negative. So I am making you retain me. In which case, the courts say that that is specific performance by another name, and they will not award that in personal services contracts. That said, though, I want to end, of course, with the Betty Davis case, Warner Brothers and Nelson, because the question is, whilst the court was quite happy to do it in that case, and certainly there's a case called Hill and Parsons, good case to look at. Lord Denning was in that case, and he found for an employee who brought an action for specific performance against an employer. And frankly, in my view, it is to be criticized. But in Warner Brothers and Nelson, there is a question as to this injunction, specific performance situation. 1937, we have Betty Davis, name at the time Nelson. She entered into a contract with Warner Brothers. She was to make some films for Warner Brothers, and there was a term that she would act solely and exclusively, or she would be contracted solely and exclusively to Warner Brothers, and that there was a stipulation in her contract that she would not, during the term of her contract, render any services for or in any other photographic, stage, or motion picture production or productions or any business engaged in that sort of occupation. Well, she got this fantastic offer from filmmakers in England, so she decided she didn't want to be bound by agreement anymore. So she left the United States via Canada, ended up in England, and made an agreement to do 2 films. Well, of course, action is brought in England, and the action was on the basis that she was seeking to get out of the contract, and she said, as far as she was concerned, this was a personal service contract, and she said her contract with Warner Brothers was tantamount to slavery. Now, why I find this case a little bit funny is because the lawyer in the case for Warner Brothers actually remarked that for the money that Betty Davis was making, and which she was calling slavery, he said that if anybody wants to put me into perpetual servitude on the basis of that remuneration, I shall be prepared to consider it. In the case, however, the court said, no, you will not make films for anybody else. The court said to her, you can do any other work, but you have to stick by your contract. So they injuncted her from working for anybody else in terms of the filming during that period of time. And they actually said to her, well, you could do any type of job you want. You could work as a sales girl at Macy's or something, not in those words, but the essence of it was you can go and do any other type of work. You just can't make pictures for anybody else but Warner Brothers during the next couple of years. So the point about injunctions, of course, is that they're generally negative, but the point to watch is, can you get specific performance by the route of an injunction? Usually not, but there are exceptions. That ends this law session on Remedies.